actually is on the floor of the House today. And the first is, where was the examination? Where was the investigation? Where was the oversight? And where is the prosecution of swindlers, crooks, bums, cheats, whatever you want to call them? And in Colorado, we had at least 3 in this last 8 or 10 years. Petters, Stanford, and Madoff. Victimized hundreds and hundreds of people in Colorado. Some of my closest friends and colleagues lost their life savings to one of these 3 crooks. And so what kind of an environment led to these giant Ponzi schemes and frauds? And I would like to thank the chairman and the ranking member for bringing forward the Investor Protection Act and some of the precautions and safeguards that are built into that we will hear on the floor of the House today. Now, the other 3 aspects of this, which is what this testimony and this hearing is about, is the bankruptcy aspects and the clawback, the reach of SIPC to anybody who was swindled and victimized by this, and finally, what tax ramifications are there. Can somebody take an immediate loss when they've been defrauded in this respect? And so we have today a constituent of mine and a friend, Mr. Pete Leveton, from Lakewood, Colorado. Pete is co-chairman of the Agile Funds Investor Committee, which represents over 200 indirect investors of Agile Group, LLC, a Colorado investment group. I've been working with Mr. Leveton and members of the Agile Funds Investor Committee for months trying to develop remedies to the inequities between direct Madoff fund investors and those indirect investors like the Agile Group. The individuals invested with Agile, and indeed more than 15,000 individuals who invested in other hedge funds who also invested in Bernard L. Madoff securities, are ordinary folk who invested their life savings in what they believe to be safe pension plans, trust funds, and investment accounts. They did their own research to determine the best investment group for their personal situations and believed that groups like Agile best suited their savings plan needs. They trusted groups like these investors to turn investments into safe legal funds. Unfortunately, Agile and other investment firms like them were defrauded by Bernard Madoff, by Stanford, by Petters, and all of the savings and funds from these individuals was lost. Under the laws written, direct investors, except now with this net investment rule, from SIPC are eligible to recoup up to $500,000 on each investment account, but indirect investors are not. Mr. Chairman, we have the opportunity to restore a piece of dignity to the indirect investors. Through no fault of their own, they lost their life savings, and some are losing their homes. They were acting responsibly and trying to plan and save for their future and retirement. And I look forward to the testimony of Mr. Leveton today to describe some of the travails of the people in Colorado.
Thank you, Mr. Perlman.
Chairman Kanjorski, Ranking Member Garrett, and members of the committee. As Congressman Perlmutter just said, my name is Peter J. Leveton. I live in Lakewood, Colorado, a Denver suburb in Congressman Perlmutter's 7th District. I am an unpaid co-chairman of the Agile Group, LLC Investor Committee. Agile was a hedge fund manager based in Boulder, Colorado. Thank you for giving me this opportunity to testify on behalf of Agile's 205 investors, several hundred Ponzi victims coalition indirect investors from more than 20 states, and by extension, all Madoff indirect investors who filed more than 11,000 SIPC claims on or before the bar date of July 2. It is clear from the statements that the congressman made earlier in this hearing that you have a clear understanding of many of the issues, and I'm going to try not to belabor those. The indirect investors are not a homogeneous group. It includes farmers, doctors, teachers, lawyers, businessmen, entrepreneurs, and other hard-working Americans who have, over a period of years, diligently saved for their retirement. Many of us are your constituents. Many of us are now devastated financially and psychologically. Many of us have sold or trying to sell our homes just to obtain money to live on. Many of us are retired. Some indirect investors have had to beg for support from our siblings and our children. Discrimination is not a word that any of us in this room would use lightly. However, because only direct investors are considered SIPC customers, discrimination is exactly what indirect investors are facing. Clearly not Congress's intent when it passed SIPA and created SIPC in 1970. Pursuant to the current interpretation, direct investor victims who knowingly invested with Madoff have an opportunity to recoup up to $500,000 for each of their accounts. Indirect investors, many, maybe most of us, had never heard of Bernard L. Madoff until it was too late. We're not considered customers. We'll recoup zero. I ask you, where is the justice in that kind of an interpretation? Because the SEC has admitted extreme culpability in missing the warning signs of the Madoff scam and others, and because the IRS essentially endorsed Madoff in 2004 by naming his firm as a non-bank custodian of IRAs and other tax-deferred retirement accounts, we believe that Congress has a duty to ensure that equal SIPC relief be provided to all victims, not just some victims, as is currently the case. The concepts outlined in the Maffei-Ellison Amendment would be a wonderful solution if it were expanded to include all indirect investors. Unfortunately, it addresses only ERISA plan victims and excludes thousands of other indirect victims, including those in self-funded retirement plans such as IRAs. I ask you again, where is the justice in that kind of an approach? We see no moral basis for Congress to amend SIPA to provide customer status to a relatively small special interest group of indirect investors in ERISA plans and exclude all other indirect investors. We, indirect investors, lost our savings to the same fraudulent Ponzi scheme, suffered the same financial devastation as the ERISA plan members and the direct investors. We firmly believe that Congress should end this discrimination, not perpetuate it, as the present draft of the Maffei-Ellison Amendment would do if passed as is. We urge Congress to enact legislation which clearly defines SIPA customers, as all investors who place their money in SIPA-protected Ponzi scheme operations. With regard to the proposed clawback amendment, we endorse an amendment that prohibits clawbacks from investors who withdrew their money in good faith and can prove that. With regard to the 60-day payment amendment, we agree that SIPC payments should be based on the customer's account balance as of their last statement, again assuming that they did not know and had no reason to believe that the Madoff operation or other Ponzi schemes were fraudulent operations. Regardless of what processing period is determined to be reasonable, we suggest that strict parameters and guidelines be established and that SIPC be required to and be held accountable for meeting those standards and guidelines. In closing, I suggest that this could happen to you, and Congressman Perlmutter mentioned that it did happen to one of the Agile investors who is a previous member of Congress. We look to you and your colleagues to carry out Congress's original intent to protect all investors when it enacted SIPA and to help us recover a portion of our tax-deferred retirement account losses. Thank you again for the opportunity to present these matters. I would be pleased to answer any questions that you may have.
Thank you very much, Mr. Leveton. And now we'll hear from our friend from New York, Congressman Fay, to introduce the next witness.
Thank you very much, Mr. Chairman, for holding this important hearing, and thank you especially for allowing those of us from other subcommittees to sit in. Just listening, I want to thank all the witnesses, and Mr. Leveton, I assure you we will be, I'm sure Mr. Ellis and I will be discussing with Mr. Perlmutter and others your suggestions. We are informed by the plight of our own constituents and don't necessarily know all of the different aspects of this. And to represent some of the folks in my constituency today, I'm very pleased to introduce a very good friend of mine, Greg Lancette, the business manager for the Plumbers and Steamfitters Local 267 in Syracuse, New York. Mr. Lancette has served as chairman of Local 267's jointly administered multi-employer trust funds since 2005. He's also the president of the Central and Northern New York Building and Construction Trades Council, representing 16,000 pensioners and their families from other unions in Central New York. Mr. Lancette, thank you for coming to speak with us. I look forward to hearing your testimony. I also want to thank Local 267's counsel, Michael Heron, for also coming down from snowy upstate New York to be with us here today. The Plumbers and Steamfitters Local 267 pension fund suffered serious losses because of the Madoff scandal. Well, while the headlines have been full of wealth and prominent investors who lost money in the Madoff Ponzi scheme, the pension funds of approximately 60,000 union workers and retirees in central and upstate New York were also exposed and suffered grave losses. Central New York unions lost at least $350 million, and as Mr. Lancette, I'm sure, will tell us, Local 267 lost approximately $37 million. It is important to help these hard-working men and women recover some of the funds they have lost. While Investor Protections Act could have provided the means to do that, I urge the chairman to continue working with me and others on the committee to address these issues after regulatory reform has passed the full House. Currently, the Securities and Investor Protection Corporation, SIPC, is allowed to advance only up to $500,000 per fund, not $500,000 per individual in a pension fund. Funds meant to support the retirement of hundreds of thousands of retirees are only eligible for the same investor protection as one person. This makes no sense, and that is why I have introduced an amendment to help workers and retirees whose pension funds were exposed to recover that money. I especially want to thank my colleague from Minnesota, Mr. Ellison, for working with me and others to get relief to the innocent workers, retirees, and business people who have become Madoff's victims. Again, I want to thank the chairman for holding this very important hearing and Mr. Lancette for sharing his story with us.
Thank you very much, Mr. Fay.
I would like to first thank Chairman Konjorsky, Ranking Member Garrett, and the representatives that consisted of the Subcommittee on Capital Markets, Insurance and Government-Sponsored Enterprises, and Representative Maffei for having me here. As you heard, my name is Gregory Lancette. I'm currently the business manager of the Plumbers and Steamfitters Local 267, Syracuse, New York. Chairman of the jointly administered multi-employer trust funds. I've served in these capacities since 2005. Local 267 is a chartered local union of the United Association of Journeymen and Apprentices in the plumbing and pipe fitting industry in the United States and Canada. I am here today on behalf of not only my 1,115 pension participants and their families, but I also stand here today as president of the Central and Northern New York Building and Construction Trades Council, which represents nearly 16,000 pensioners and their families also from Central New York. Today I would like to discuss the direct relationship between SIPC and Bernard Madoff's Ponzi scheme. SIPC today provides coverage to individuals with an individual limit of $500,000, but my members' pension investments have no real coverage. Because my members, like millions of workers across the country, rely on pooled investments for their future retirement, SIPC coverage does not currently protect them. The Local 267 benefit funds first invested with Madoff Securities in the mid-1990s. When I was elected in 2005, the Madoff investment was approximately 30% of our pension fund. We received regular